When we talk about parental alienation as lawyers, precision matters. This is not a theoretical debate. It is about conduct that multiple legal systems already prohibit in plain language. I want to ground this discussion not in commentary, but in the words legislatures and treaty bodies have actually used. I will start with international law, because it provides the clearest statement of the child's right that underlies every domestic framework. Article 9, Paragraph 3 of the United Nations Convention on the Rights of the Child states, and I quote, "States parties shall respect the right of the child, who is separated from one or both parents, to maintain personal relations and direct contact with both parents on a regular basis, except if it is contrary to the child's best interests." That sentence matters. It does not say parents have a discretionary privilege. It says the child has a right, and the state has an obligation to respect it. That principle is binding on ratifying states and persuasive authority, even where not formally incorporated. Germany provides one of the clearest statutory articulations of this principle in domestic law. Section 1684, subsection 1 of the German Civil Code states, in the official English translation, "The child has a right to contact with each parent. Each parent is obliged and entitled to have contact with the child." The statute then imposes a clear behavioral duty. Section 1684, subsection 2 states, "Each parent shall refrain from anything that could impair the child's relationship with the other parent or seriously interfere with the upbringing of the child." Germany does not treat interference as co-parenting difficulty. It treats it as a violation of a legal duty owed to the child, enforceable by court order and sanctions. Canada follows the same principle through federal statute. Section 16(3) of Canada's Divorce Act requires courts to consider the willingness of each person, in respect of whom the order would apply, to support the development and maintenance of the child's relationship with the other spouse. Canadian courts repeatedly interpret that language to mean that a parent who undermines the child's relationship with the other parent is acting contrary to the child's best interests. The United Kingdom expresses the same idea through presumption rather than duty language. Section 12A of the Children Act 1989 provides, "A court is to presume, unless the contrary is shown, that involvement of each parent in the life of the child concerned will further the child's welfare." British courts have emphasized that involvement includes emotional, relational, and practical participation, and that deliberate obstruction of that involvement is inconsistent with the child's welfare. Brazil is especially important to address because it is one of the few countries that enacted a statute explicitly naming parental alienation, and it is also the country most often cited correctly or incorrectly in debates about misuse. Brazil's federal law, No. 12.318 of 2010, defines parental alienation in Article 2. The statute provides, and I quote from the official English translation commonly used in comparative law analysis, "Parental alienation is considered to be the interference in the psychological formation of the child or adolescent promoted or induced by one of the parents, grandparents, or by those who have the child or adolescent under their authority, custody, or supervision, so that the child or adolescent repudiates the other parent or causes damage to the establishment or maintenance of bonds with this parent." The Brazilian statute then lists specific examples of prohibited conduct, including obstructing contact, disqualifying the other parent's conduct, and presenting false allegations to prevent coexistence. The remedies authorized by Brazilian law include warnings, fines, modification of custody, and other judicial measures intended to protect the child's relationship with both parents. It is critical, especially for attorneys, to note two things at once. First, Brazil's legislature made an explicit legal determination that parental interference causing relational rupture is harmful conduct warranting statutory intervention. Second, Brazil's law has been subject to serious criticism and reform debates due to concerns about misuse in cases involving domestic violence allegations. That controversy does not negate the legal principle underlying the statute. It reinforces the need for evidence-based application, safety analysis, and judicial rigor, precisely the same safeguards required in every jurisdiction. Several other civil law countries reflect the same principle without using the alienation label. In France, the Civil Code recognizes the child's right to maintain personal relations with each parent, and courts have treated unjustified obstruction of contact as a basis for sanctions and modification of parental authority. French courts frequently refer to obstruction of contact as a violation of parental obligations rather than a private dispute. Spain similarly recognizes the child's right to maintain relations with both parents, and Spanish courts have sanctioned parents for obstructing contact, particularly where the obstruction is repeated and unjustified. In Argentina, while statutory language has evolved, courts have repeatedly recognized that obstruction of the child's relationship with a parent violates the child's rights and can justify judicial intervention. Argentina's jurisprudence increasingly frames interference as harm to the child rather than misconduct between adults. Mexico provides another instructive example. Several Mexican states have enacted provisions recognizing interference with parental relationships as harmful conduct. And courts have imposed sanctions where one parent obstructs the child's relationship with the other. As in Brazil, these laws have sparked debate, but the underlying principle that the child's relationship with both parents is legally protected is firmly established. Turning back to the United States, the same principle appears repeatedly in state law. California Family Code Section 3020 B states verbatim, "It is the public policy of this state to assure that children have frequent and continuing contact with both parents after the parents have separated or dissolved their marriage, and to encourage parents to share the rights and responsibilities of child rearing." Florida Statute Section 61.133 requires courts to consider the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Arizona Revised Statute Section 25-403A6 requires courts to consider which parent is more likely to allow the child frequent, meaningful, and continuing contact with the other parent. Texas Penal Code Section 25.03 criminalizes interference with child custody, providing that a person commits an offense if they knowingly take or retain a child in violation of a court order. New York appellate courts have repeatedly held that a parent's interference with the other parent's relationship is so inconsistent with the best interests of the child as to raise a strong probability that the custodial parent is unfit to act as such, language that appears across decades of New York custody jurisprudence. Wisconsin Statute Section 767.41 requires courts to consider whether a parent is likely to unreasonably interfere with the child's continuing relationship with the other parent. And Wisconsin appellate courts have made clear that this factor must be addressed when supported by evidence. Finally, at the level of human rights enforcement, the European Court of Human Rights has repeatedly held that state failure to take effective measures to enforce parent-child contact can violate Article 8 of the European Convention on Human Rights. In Ignicolo Zinaid v. Romania, the court held that authorities must take adequate and effective measures to facilitate reunification, and that prolonged inaction can itself constitute a violation of the right to family life. That principle is critical for attorneys. It establishes that failure to act is not neutrality. It is state responsibility. When you line these authorities up the United Nations Convention on the Rights of the Child, the German Civil Code, Canada's Divorce Act, the UK Children Act, Brazil's federal law, No. 12.318, civil law jurisprudence in France, Spain, Argentina, and Mexico, U.S. statutes in California, Florida, Arizona, Texas, New York, and Wisconsin, and European human rights case law, the conclusion is unavoidable. Across jurisdictions, the law says the same thing in different words. Children have a legally protected right to maintain relationships with their parents. Parents have a legal duty not to undermine those relationships, and the state may not permit those relationships to be destroyed without justification, evidence, and due process. That is not psychology. That is law. And once that is understood, parental alienation ceases to be controversial. It becomes what these statutes, codes, and treaties already describe: unlawful interference with a protected family relationship.